Hello, everyone, and welcome to Uncivil Law. And for today's case, we have a potential police misconduct, abuse of an elderly person, an arrest that was done with improper violence. This is the case of Bruce Bartley versus City of High Point. In this case, a police officer conducted an arrest of an elderly man and did so potentially improperly and potentially in a way that was very rough indeed. And so they're being sued. And the court said, yeah, you can sue them. And so they're on appeal saying, no, I don't want to be sued very much. And so the court has to decide whether or not this officer can be sued for the things that they might have done that was wrong. Let's get started with this case. On August 23rd of 2017, Officer Blackman, a police officer within the defendant's city of High Point, was driving an unmarked car when he observed the plaintiff pass a slow-moving truck over a double yellow line in violation of North Carolina law. So he passed a double yellow line. That is a no-no. Officer Blackman believed the truck was not moving so slow as to impede the flow of traffic and decided to initiate a traffic stop of the vehicle that had crossed the line. Though Officer Blackman's official job duty is as a detective in the violent crime unit, so maybe he's a little bit used to violence, he also occasionally engages in traffic enforcement. So this guy, who's a specialist dealing with violent crime, also from time to time does traffic enforcement. A little odd, but that's what we're doing. We're doing a traffic enforcement for this guy who does violent crime unit for some reason. As he began to follow the vehicle, Officer Blackman testified that he activated his blue strobe light and siren. Blackman believes he'd soon be able to draw enough to the plaintiffs, that such a plaintiff should have reasonably been able to see the lights and sirens. However, he was unable to get close enough to the vehicle to initiate a traffic stop. He observed the plaintiff make a left-hand turn onto a street leading to a residence at a speed which made him become concerned. The plaintiff was aware he's behind him and was attempting to make it to a residence. Officer Blackman further testified that based on training experience, it is not uncommon for people to try to get into a driveway and park their vehicle. So this guy's trying to initiate a traffic stop. The vehicle that he's trying to pull over had pulled past a truck, I'm assuming a semi. And so he pulled past a truck, and so he puts on his lights and siren and starts to try to get to him. But he's still kind of behind the guy. So he thinks, oh, he can't really see me. But then he sees this car pull off into a residential neighborhood. And he's thinking, oh, maybe he does see me. He's trying to evade me. You know, I've seen this before where a person will try to get to a residence and try to escape that way. So he's thinking to himself, maybe that's what's happening. So he's trying to follow up on this. The plaintiff, who was 60 years old at the time, testified he exited his vehicle and was headed to the back of it when he first noted Officer Blackman. Officer Blackman got out of his vehicle and twice ordered him to get into his car. The plaintiff testified he was unaware that Officer Blackman was a police officer and also did not notice the blue strobe lights on the vehicle. He told him he was in private property and refused to get back in the car. So of note here, this is an unmarked police car, and he himself is plain clothes because he's a detective. He's not a trooper, so he's not in a uniform. And so the vehicle looks like a normal vehicle. It's not marked in any way. And he himself is not dressed as an officer. And the guy says, I couldn't see his blue flashing lights. Maybe, maybe not. Depends. Sometimes they can be a little bit subtle. So I've definitely seen him. So maybe he couldn't see it. And he couldn't tell from the police uniform, from his uniform, because he didn't have it. And he couldn't tell from the car. So to him, he says, it just looked like to me to a guy. It just looked to me like a guy yelling for me to get back in my car. And I'm like, I'm not going to follow the request of this random guy. Because, no. The plaintiff testified that as his back was turned, Officer Blackman body slammed him against the truck of his car, handcuffed him, and informed he was being detained. After he was handcuffed, he then turned and noticed the badge and service weapon on his belt. Officer Blackman charged the plaintiff with resisting, delaying, or obstructing an officer in violation of North Carolina law for ignoring his commands and tensing his arms while being handcuffed. For the traffic violation, plaintiff completed driving school and community service, and the other charges against him were dropped. On the 28th of December 2018, plaintiff filed a complaint against the city of High Point and against Officer Blackman in both his official and individual capacity, alleging assault and battery, false imprisonment, false arrest, and malicious prosecution. In his complaint, the plaintiff alleges that he was forcibly thrown against the trunk of his car, handcuffed, and charged with resisting an officer. In response, defendant asserts the defenses of governmental and public officer immunity. So the officer says, well, I was acting in my official capacity, And so I have immunity for these actions because you can't sue me personally. You might be able to sue me officially under 1983, what raises its own set of problems. But in trying to sue me personally, you can't do that because I was acting within the scope of my official role. And so I have official immunity. You can't get to me personally because I was acting in that capacity. So the question is here, the exposure under his personal immunity. Is this only official acts, or are we looking to non-official acts as well? Let's read on. On appeal, Officer Blackman contends the trial court erred in partially denying the motion for summary judgment on defense of a public official immunity and on the claims against him in his individual capacity. Officer Blackman contends that because he was a public official conducting duty, he is entitled to protection of public official immunity. Public official immunity is a derived form of governmental immunity which protects suits against public officials in their individual capacity. A police officer is generally immune from suit in his personal capacity unless the challenged action was done outside the scope of the authority, was done with malice, or was corrupt. Here, plaintiff alleges Officer Blackman acted with malice by body slamming him into the trunk of a car and charging him and arresting him for resisting an officer without probable cause, and therefore is not entitled to immunity. Thus, a malicious act is done if it is done wantonly, contrary to the actor's duty, and intending to be injurious to another. So we can only get to the officer individually if certain things are true. If you're acting outside of your official capacity would be one. Another one would be if we did it with malice. We did it with particular hatred. And so to find malice, to find this hatred, we have to find a couple things. That it was done wantonly, that it was contrary to the duty that you had, and it was intended to be injurious. So we have to show these things to show that you were acting outside of your official capacity. So were you acting with the requisite malice? To figure that out, we have to look at all the elements that would make up a malice act. The wanton nature of it, that was contrary to duty and intended to be injurious for injury's sake. So the court is now going to analyze each of these three things to find out whether or not it was malicious. So let's read on. We first consider whether Officer Blackman acted wantonly and contrary to duty. An act is wanton if, when it is done, of wicked purpose, or was done needlessly, manifesting reckless indifference to the rights of others. It is well established a law enforcement officer has the right, in making an arrest and securing control, to use only such force as may be reasonably necessary to overcome any resistance and properly discharge the duty. Thus, a police officer may be held liable for assault and battery in the course of the arrest if they use unnecessary or excessive force to effect the arrest. Here, there is question of material fact as to whether Officer Blackman used unnecessary and excessive force. Viewing the evidence in the light most favorable to the non-movement, there's also a question of fact as to whether Officer Blackman's alleged conduct was wanton, such that it was done needlessly, manifesting a reckless indifference to the right of others. Regarding the plaintiff's claim for false imprisonment or false arrest, he alleges that Blackman did not have probable cause to arrest him, and thus acted contrary to duty. False imprisonment is illegal restraint of a person against the will. A restraint is illegal if it's not done lawfully or consented to. A false arrest is an arrest without legal authority and one means of conducting the false imprisonment. So there's also this claim of false arrest that we have to analyze and figure out whether or not any of that was applied. So to figure out whether it's false arrest or not, we have to figure out whether or not it was within the scope of the duties or not. So let's figure out whether it's within the scope of those duties. Officer Blackman, citing to our decision, argues that during a stop, in order to maintain the status quo or to ensure safety, police are authorized to engage in conduct and use forms of force typically used during a formal arrest. This may include placing handcuffs on suspect, which remain at least the least intrusive means reasonably necessary to carry out the purpose of the stop. Because the plaintiff ignored Officer Blackman's commands to get in the car, Officer Blackman believed the best course of action was to restrain him by placing in handcuffs. However, there's a genuine issue of material fact as to whether body slamming the plaintiff in the course of the arrest was necessary or outside the bounds of the duty. So we're not making the determination yet, but we're saying that there might be an issue here. There might be an issue for the court to decide. Maybe it was necessary, maybe or not. But maybe it was so outside the scope that it does reach this level. So there's an issue for the trial court to adjudicate. So we're too early in the process to determine whether the police officer acted responsibly or not. Go back to trial and figure out whether or not those things are true. But you can go to trial. We lastly consider whether the third element of malice is met, whether Officer Blackman acted with intent to injure. With respect to this element, malice can be proven by showing of actual or implied intent to injure. To satisfy implied intent, a plaintiff must show that an officer's conduct was so reckless or so manifestly indifferent to the consequences where the safety of life or limb is involved as to justify finding a willfulness and wantonness equivalent to the spirit of actual intent. In a prior case, we found out the defendant police officers were not entitled to summary judgment on the issue of public official immunity where the plaintiff presented evidence that they used unnecessary and excessive force during an arrest. Similar to the prior case law, in the present case, the plaintiff alleges Officer Blackman used unnecessary and excessive force when he arrested the plaintiff. Specifically, the plaintiff testified in his deposition that Officer Blackman ordered him back to his car while standing in the driveway of his private residence without first identifying himself as police or explaining the reasons for his presence. In addition, Officer Blackman was wearing plain clothes, driving an unmarked vehicle, and plaintiff says that he did not notice any lights or strobe lights on the vehicle, and Officer Blackman's police badge was hidden away from initial view. Though Officer Blackman alleges he believes plaintiff should have reasonably known he was a police officer and contests the assertion that he body slammed the plaintiff, on a motion for summary judgment, we view the facts in the light most favorable. So again, we're not making any findings here. We have to assume the most extreme version of the case that's consistent with the pleadings. So whether or not any of this is true, we're not sure. We assume it for the purpose of summary judgment, because if you lose under the most extreme version, there's no reason to determine the facts. But here, you don't lose under the most extreme version of the facts. So we're not making the finding. We're simply saying that, if this were all proven, the officer might have some liability. Viewing the facts in the light most favorable to the plaintiff, therefore, Officer Blackman body slammed, again, in the light most favorable, then he would have body slammed a 6-year-old unarmed man who was not being threatening or attempting to run away. In keeping with our reasoning in the case law, Officer Blackman's rough use of force in arresting an elderly, non-threatening man in an attempt to cite him for a traffic offense raises a genuine dispute as to whether or not there was the requisite malice. For the foregoing reasons, we affirm the trial court's partial denial of summary judgment, allowing this to become a triable issue. So that is the end of our coverage of the case of Bruce Bartley versus City of High Point. In this case, there was an issue as to individual immunity of the police officer, whether or not he was individually immune. And for that to be true, he would have had to be acting within his official capacity, and he would have had to not been acting with malice. And here the court says that under the version of the facts Bartley suggests, there might be enough to find the malice. They're not finding it, they're just simply saying it's a triable issue. So you have to go forward and find a little bit more and adjudicate whether or not these things happened, and if they did, whether or not it's within the bounds of valid police procedure or not. So the Court of Appeals is simply saying, yeah, we allow this to develop a little bit more. It's a little bit early to hold immunity. The police officer may be responsible, and even if the police officer did everything that they said they did, he still may not be responsible. Maybe it was all proper. But the trial court needs to figure that out in the first instance. But for our purposes, that's the end of the coverage of this case. Thank you for joining me as we both read this case together and now better understand the law. If you're enjoying this legal education content, please subscribe to this channel. It really helps us grow. And check out one of our other videos, including the one that's currently being displayed on the thumbnail on screen. Thank you so much for your continued support. And until later, my friends, cheers and goodbye.